Hello, this is Jeff Brown. I'm here with David Dick. Welcome to our Thompson Coburn CLE webinar on arbitration and other forms of ADR. David and I will discuss today ADR provisions for real estate transactions, but the concepts apply broadly to other commercial transactions as well. We want to give you an overview of the different alternatives you have so that you can make an informed decision when you are negotiating your transaction documents. We'd like this webinar to be interactive, so please send us your questions or comments by using the chat button at the top right of your screens. The methods used to resolve breaches of the deal documents are not boilerplate, but important. And of course, negotiating the dispute resolution provisions during the negotiations is much better and easier than trying to figure it out after a dispute is already brewing. When the parties are discussing the deal, parties are more flexible and amicable, at least to some extent. We're going to talk about the choices of plain vanilla litigation versus arbitration versus the California Judicial Reference Procedures and the Missouri Special Master Procedures. Also, we're going to talk first about mediation. As we go through our presentation, we'll note the takeaways for the next time you've got a deal to negotiate. So let's start, please. As you can see, the first thing to take a look at is we're talking about introduction to history. The first thing to look at is venue selection and choice of law. Everyone has seen those provisions. Where's the dispute going to be resolved, and what's the law that's going to apply? Just a quick war story before David gets going on that. You got to be really careful about this. My first introduction to the fact that these kind of provisions are not boilerplate, as some deal people sometimes think, is I was litigating a matter that had a provision that was supposed to say that all the disputes are to be resolved in New York. Unfortunately, the person who was drafting the document instead cut and pasted only half of the provision. So I had to convince the judge that what the other half was supposed to be. It became a much more complicated and difficult procedure. Fortunately, we were able to do that. But again, had the provision been drafted a little more carefully, we wouldn't have such a problem. David, if you wouldn't mind, let's first talk about the choice of law and choice of forum.
Sure. Thank you, Jeff. Again, this is David Dick. Good afternoon or good morning to some of you folks on west of Missouri. Our title referred to ADR and arbitration, but we wanted to start off with just a very brief discussion of choice of law and choice of forum provisions. And choice of law provisions, again, without going into detail, a choice of law provision is simply a statement that chooses a particular state's substantive law. And obviously, without going into details, there can be significant differences among different states' law. So pick one that's favorable to you, and we'll talk more about it. But there needs to be some relationship to the parties or the transaction at issue in order for a choice of law of a particular state's law to be enforceable. But again, whether you choose to arbitrate, in other words, whether there's a mandatory arbitration procedure or the default of litigation, a choice of law provision is very important. Similar but different, a choice of forum provision. Again, we'll talk a lot today about ADR, but if you choose in your transactional document to default to litigation, we think it's important that you put yourself in the best position possible and choose the forum where you would rather be. Again, there are lots of examples out there on how to word that, but you want to use very specific language such as any and all litigation shall be filed, or use the buzzword exclusive forum, again, to put yourself and your client in the best forum possible. Again, both choice of law and choice of forum provisions are enforceable. There was a U.S. Supreme Court case roughly a year and a half ago. Atlantic Marine was the style of the case. And the Atlantic Marine case made it very clear that federal courts will give tremendous deference to choice of forum provisions, as long as there is some relationship to the parties or the transaction at issue. And again, without going into all of the exceptions, these choice of law and choice of forum provisions are much more likely to be enforced when it's a business versus business situation between sophisticated entities as opposed to consumer-type contracts. There are other statutory exceptions, such as employment discrimination claims. Some states recognize are exceptions to choice of forum and choice of law provisions. But again, the main takeaway Jeff and I want to make sure everyone keeps at the front of their brain and not the back of the brain, is in crafting any kind of transactional document, if you're creating ADR provisions or choice of forum provisions, choice of law provisions, just make sure they're consistent with one another. Problems often arise, as Jeff alluded to, with cut and paste documents. They often arise in the context of the traditional UCC battle of the forms, where there is a series of purchase orders and confirmations, and one side has an exclusive forum provision and the other side's forum have arbitration. And if the documents are inconsistent, the court will just default to litigation as if there is no procedure. One situation where I've seen this arise, I've noticed a case recently, was a situation where there was a document that was in bold and underlined in all caps, master agreement, and the master agreement had an arbitration provision, but then all of the subsequent sales documents and purchase orders had an exclusive forum provision. And there the court said, well, just because you call it a master agreement doesn't mean you can't later amend it. It doesn't mean you can't later come up with some other enforceable contract. So we're going to enforce the choice of forum provision. It was in the later sales document. So again, something to track. So again, the takeaway there is choice of law is always helpful. Choice of forum is really very important if you want litigation. And the more difficult question, and what we'll dive into now, is the things to think about in making that choice of whether you want to go to litigation in the forum of your selection or whether you'd prefer arbitration and the other ADR provisions such as mediation or others. So with that said, I'll turn that over to Jeff.
Thanks, David. Before we get going onto this slide, just a follow-up for what David was saying and emphasizing. I've done a lot of commercial real estate litigation over the last several years, and one thing that I've seen, unfortunately, time and again, is when you have multiple transaction documents with respect to a real estate sale or a lending document, sometimes they don't match because different people are doing different documents, and again, because of this concept of maybe this is just boilerplate stuff we don't have to worry about now. That becomes a problem later on when there's a dispute. If there's a choice of law that says California and another document says New York, then the judge has a problem in deciding how to enforce that. So again, consistency is important, as David pointed out. This chart in front of you, litigation versus arbitration versus judicial reference, I'm not going to go through everything, but this is a great cheat sheet to basically put away somewhere for the next time that you've got a deal and you're trying to decide what's the best situation for you. I'm just going to emphasize a few of the factors to take a look at. Again, select a try or a fact. Litigation, obviously, you're just given whoever the judge is, subject to some types of procedures. Arbitration, judicial reference, yeah, you can figure out a situation where you and the other side have a procedure for choosing someone, usually a retired judge or a lawyer, to decide your matter. Location, again, David talked about the forum selection clauses. Discovery allowed, that's a big deal with respect to deciding what to do later on, because discovery is if it's not the most expensive part of resolution or litigation, it's certainly up there because of all the depositions and documents and interrogatories. You're allowed to, with respect to arbitration, judicial reference, and litigation to some extent, try to limit discovery. Again, it's going to have some provisions in California especially that say that the arbitrator or the referee can still increase the number of discovery requests upon a showing of good cause. Right to appeal, that's a big thing to take a look at. Some people just, a lot of sophisticated business people just want to get it over with, so they like the idea that arbitration is very limited in terms of what you can do after the award, but some people want that ability to have at least somebody take a look at an arbitrator's decision or the trier of facts decision, and that's why judicial reference might be the great hybrid that we'll talk about a little later on. Confidentiality, again, a lot of business people don't want their laundry in front of the public. Arbitration is really the best way for that. We'll talk about. Again, stare decisis, predictable results, rules of evidence, important things to think about. Speed of resolution and cost, those are important to a lot of people as well. Can I get this thing resolved quicker than going to court? As you'll see, arbitration may be fastest because you've got the trier effects, you know, the ability to have that person focus on it as opposed to going to court. Best example in California very recently, if we had tried a matter in front of the judge, we probably would have got only 4 hours of testimony a day because he had other things to do. With an arbitrator that we ended up stipulating to, we ended up with something like 8 hours of testimony, so that went much quicker, much faster. And again, that also ties into cost. Again, litigation, you don't have to pay for the judge. Arbitration, referees, you actually do. And then a very important part is the idea of the concern about jury. California, for example, doesn't allow you to have a pre-dispute contractual waiver of jury, but on the other hand, California says, hey, go to arbitration, go to judicial reference, and you end up with the same result. You end up with a waiver of the jury. So David now is going to first talk about mediation, which hopefully would resolve the dispute before you even get to any of these others. David?
Yes, thank you, Jeff. And just to briefly talk about mediation. Mediation is the most common form of non-binding alternative dispute resolution. And again, I know many of you are probably very familiar with mediation, but something to keep reminding business folks and your internal clients is nothing is decided in mediation. It is not binding. It's basically just a third party presiding over settlement negotiations. But I have one client who I've had, I think, 3 arbitrations go to decision, a couple others start. We've done several mediations, and every now and then he'll still ask a question of what's the mediator going to decide, and I have to steer him back to remember mediation is just a third party presiding over settlement negotiations. One thing Jeff and I wanted to point out is, and you see this more and more, at least I often work in the construction context, and there are more and more construction contracts, at least over the last 5 or 10 years, that require a meeting of executives, and obviously executives can be defined further. But while some contracts require mediation, and just that very general reference to mediation, some specifically require a meeting of executives, and I've seen them reference to executives at a vice president level or higher, or a corporate officer or official. In other words, requiring somewhat of a cooling off period, but requiring the business people, the business decision makers to sit down together to try to work through the dispute. And we think it's important as the draft of the documents, or certainly as an in-house counsel, to think about, is this more advantageous for your business to have a meeting of the executives as opposed to a mediation where lawyers tend to be involved and where lawyers and the mediator tend to have more control over the process. And one example I thought of is I have done a fair amount of work for a manufacturing company that basically manufactures components that are sold to OEMs, so they're a producer of goods in a chain of sales that end up with some other end user who my client never deals with. So their relationships with their OEMs and with their suppliers are absolutely critical. And for them, it's really important to sit down and have a meeting of the executives, and they would rather have that as opposed to a mediation where lawyers are involved, where a lawsuit's been filed. In other words, where everything has really been teed up before the business people talk. And courts do enforce these provisions. There are loads of cases out there from courts all over the country where courts have dismissed lawsuits because of one party's failure to participate in mediation as they had agreed to do in a contract. Similarly, I think a court would enforce a requirement of a meeting of the business executives before filing a lawsuit. Now, that dismissal is typically a dismissal without prejudice, meaning the parties have to go back and go through the procedures before teeing up the lawsuit or moving ahead with the lawsuit. But if it's something that is important to your business, we certainly think that's worth including. And also there's a catch that, at least in California, and I know Jeff can address this further, a party may not be able to recover attorney's fees, even if that party wins, if the contract required mediation and the ultimate winner blew it off. So our takeaways here in crafting an ADR agreement, whether it's mediation or a meeting of the executives, is you can require that. You can require a meeting of the executives. You can require a mediation. You can require a mediation with certain level executives. You can write that into the agreement. And although many, if not most contracts today, especially in the construction and real estate arena, require mediation, a lot of those contracts really don't say much about the details of mediation, and that's what Jeff is going to turn to next.
Thanks, David. And just keying off what David said, as a lot of you who have done work in California know, the case law does support the idea that if there's a provision in a real estate deal that says you must mediate before you go to arbitration or litigation, and if you don't, you've waived your right to attorney's fees even if you win, those are enforceable. And in fact, I'm sure some of you have dealt with the CAR forms and the California Association of Realtors, and they have such a provision in their commercial purchase and sale documents. So let's first now take a look at mediation and the key elements of mediation. The top, first we have a question is, how do you avoid delays? If you're going to mediation and then you go to arbitration, how do you know the other side isn't going to be able to just keep on going and stall this thing out? And that's a really great question. And that's why when you're documenting these kind of deals, you want to put in deadlines. You want to put in deadlines for selecting a mediator. You want to have a deadline that says that the mediation must take place within X days after the demand for mediation goes out. Same thing obviously applies for arbitration. Now, in practice, at least in California, because everybody has difficult scheduling, a mediator or an arbitrator sometimes doesn't get to it as quickly as you want. But if you've got these deadlines in place, it really does help get the process going quickly. And obviously, it helps in the sense of if the other side's stalling out on the mediation, you demand it within the time specified in the deal documents. If it doesn't happen, you have a much better argument of then moving forward with the arbitration or the litigation. Again, here's some of the elements to take a look at. Selection of the mediator. When you go into these mediations, I consider that one of the most important, if not the most important point to take into consideration. If you have a terrible mediator, you've got one of these retired judges who all he wants to do or she wants to do is pound on your client and say you're going to lose, you're going to lose. These days that doesn't work. It might have worked back in the day, but here we've got sophisticated business people. They understand the risk because you've discussed these with your client. And instead you need someone who understands and has finesse to deal with the clients, the personalities, and to suggest a business resolution that would be best for getting out of here. One mediator told me that the best resolution that he had was when both sides went out equally unhappy. The location of the mediation, obviously important. Again, you want to key that into also the venue provision of where the dispute's going to be resolved. You don't want to keep going back and forth. Preliminary exchange of information, again, important things. You want everybody to understand what the issues are, but sometimes, as you can see, sometimes you want to give the mediator some information you don't want the other side to have, but it would help the mediator in terms of the negotiations. Persons with authority present in mediation, again, very important. If someone on your side or the other side isn't there to try to settle this thing, but they send someone without authority, it makes it obviously much more difficult to get the deal done. And then keep the status quo. One of the important things that people always get worried about, especially in real estate deals, is, well, you know, how do I know that the seller, while I'm going through mediation, doesn't just try to flip the property to a BFP, bona fide purchaser, and then I'm out of luck? The idea for a lot of these ADR provisions is you want to have something in there that says you're allowed to keep the status quo, you're allowed to record lis pendens, you're allowed to get an injunction, you're allowed to get an attachment, so that the parties have the status quo and keep it there while you're trying to resolve it. And again, deadline to compete, that important thing that questioner asked about, you got to keep these things rolling. The other thing that we'll talk about, and David will talk about a little bit more, is the idea of the kumbaya session, whether you want the parties to all get together and talk about things. Again, something that I don't particularly like, because usually clients, both parties are not exactly happy with each other, and having them face off with each other and say why they hate each other doesn't really move the process towards resolution. David?
Great, thank you, Jeff. And before we jump into the detailed discussion of mediation, we have a movie clip for you. And why I chose this movie clip, this is from Intolerable Cruelty, a Coen Brothers movie, I think around 2000, with George Clooney and Catherine Zeta-Jones. Why I chose this one is it's my favorite lawyer movie. This particular scene, to tee it up, is the first meeting between a soon-to-be ex-husband and wife, their first meeting with their lawyers, their first meeting since the wife, who is somewhat of a gold digger, as the movie makes clear, the wife had set up a sting operation of sorts where she caught her soon-to-be ex-husband with another woman, and she's now contemplating how she's going to get rich out of it.
Freddie! Freddie Bender, this is Rex Roth, and you are the lovely Marilyn.
Please, Miss Rex Roth. And you must be Mr. Massey.
Please, Miles. Sit down. Oh, Freddie, I was sorry to hear about the Goldberger Award. Pastry?
We did very well. We did very well.
Not to worry, Mrs. Rexroth. You're ably represented. I'm sure Freddie's just too modest to tell you he used to clerk for Clarence Thomas. Pastry? Going begging.
Don't try to bait me, Miles. Now, if you have a proposal to make, let's hear it.
Well, at this point, my client is still prepared to consider reconciliation.
My client's ruled that out.
My client is prepared to entertain an amicable dissolution of the marriage without prejudice.
That's a fart in a stiff wind.
My client proposes a 30-day cooling-off period.
My client feels sufficiently dispassionate.
My client asks that you not initiate proceedings pending his setting certain affairs in order.
Well, what's so goddamn funny?
Please, let me handle this. All right. So much for the icebreakers. What are you after, Freddie?
My client is prepared to settle for 50% of the marital assets.
Why only 50, Freddie? Why not 100? While we're dreaming, why not 150? Are you familiar with Kirshner?
Kirshner does not apply.
Bring this to trial. We'll see if Kirshner applies.
What's Kirshner?
Please, let me handle this.
Kirshner was in Kentucky.
Kirshner was in Kentucky?
Kirshner was in Kentucky.
All right, Freddie, forget Kirshner. What's your bottom line?
Primary residence, 30% of remaining assets.
What are you, nuts? Have you forgotten Kirshner? Freddie, it's a negotiation.
See you at the preliminary.
Freddie, we're all friends here. It's a negotiation. Hey, Freddie, fine. We'll eat the pastry. I thought that went well.
Okay. So we'll talk some about how to get the most out of mediation, how to keep your client, your particularly internal client, your business folks happy with the process and with you. The first point, and George Clooney probably fell flat there, develop with your client a game plan as to what the desired outcome is, who will talk, how you're going to react to things, when the client should ask questions or interject, when the client should not, client meaning business person, when the business person should not interject. You definitely want to have a very detailed plan as to all of those items, including I often work out a plan with a client where I have, if the client wants to talk and they make it clear they want to talk, where we have some kind of high sign that, so they understand when I give a sign that they should punt it back to me. Again, George Clooney, although he had a plan to bait the other side there, it was apparent that he did not have a plan with his client as to what to expect and not to interject and that sort of thing. Another really critical point, call the mediator in advance. This is one takeaway that I think a lot of lawyers just overlook and just don't do. We often think of everything relating to disputes in terms of ex parte ethical rules. And there is no ethical prohibition on contacting a mediator. Some mediators may not want to talk to the lawyers, but I think most do. My experience is most mediators love to talk to the lawyers. Because obviously mediators, why they are skilled is they enjoy the psychology of it. They enjoy trying to read the people involved in the dispute. And they want to hear that information before the mediation starts because that helps them do their job much more effectively. Again, one war story example, I once had a dispute that went to mediation. I represented a general contractor who built a building for an owner. The owner said they weren't happy. The owner didn't pay my client. And the backstory of the dispute was the owner and my client, my contractor client, had been great friends years before. The owner was, there was a husband and a wife. The wife was much more receptive to hearing our side of the story, much more receptive to reason. The owner the husband was more of the kind of guy who always wanted to be right. There was no way he would accept that he would be wrong. And after explaining all that to the mediator, the mediator told me afterwards it made all the difference because he understood the dynamic. He understood the dynamic between my client, between both sides of the dispute, and between the husband and wife, and said that the way he teed it up was to make the husband feel like he was being magnanimous whenever he would make an offer or somewhat concede our position, as opposed to accepting that we were actually had a legitimate basis. So another thing to think about is, does your client need a mediator to explain the risks and burdens, not just of litigation in general, but of this particular dispute? We all get caught in situations sometimes where it's difficult as a lawyer to explain that to the client. The mediator can certainly help. Another suggestion, I think it's important to talk to the mediator ahead of time and share your suggestions on how to conduct the mediation. You know, Jeff used the buzzword earlier of kumbaya session. Some mediators like to have a session where at the start of the day, both sides, all the participants and their lawyers get in the same room and state their positions, basically, an opening statement of sort. Some mediators like that. Some mediators do not like that. I think most are flexible. And it's important to consider whether that opening statement where both sides show some cards and both sides explain their position to the other would be helpful, or would that just merely throw gasoline on the fire? Because there are plenty of times when it is not advisable to get the parties in the room together because it would just harden feelings, make things worse, and possibly just blow the whole thing up. It's also really important going into a mediation to assess ahead of time what is the risk, what is the need to settle the claim that day. Again, in thinking of the business side of things and the CFO or your business person's mission on going into mediation, the great thing about a mediation is all the decision makers are in the same building. So if you have a situation where the dispute needs to get resolved, mediation is a great way to tee that up and make that happen. On the flip side of things, sometimes mediation is just one step in the process, and you want to view it as that, as you have an opportunity to settle it that day, but you certainly don't have to. And you may be able to maximize your recovery or minimize your payout by using the mediator and using the process after you were there that day to get your case settled. You know, there's a mediator's tactic we refer to often as a mediator's number or a double blind, where at the end of the day, if you have a dispute where, say, the claimant wants $1.5 million, the defendant is only willing to pay $1 million, at the end of the day, you may want to actually propose this to the mediator of, okay, the mediator is going to propose $1.25 million, and both sides have 3 days after the mediation to call and say yes or call and say no. You can't come up with some other number. It's just merely a yes-no answer. And if both sides say yes, then you have a deal. If you say yes and the other side says no, you know that because you said yes. If you say no, you don't know whether the other side said yes or not. So it's not only is it a creative way to get the case settled, but it also can give you more information if you are the one willing to settle. So again, just to put a gloss on that, in any mediation, it's important to tee up how you want to end the day. How do you want to walk out of the room? Do you want to walk out and storm out? Do you want to propose a mediator's number? Because you can take advantage of that process. And again, it can continue beyond that day. To flip the page and talk a little bit about arbitration. Assume you had a mediation agreement and assume it fails. What about arbitration? And in drafting an arbitration agreement, the most important thing to remember is a written contract is the basis of everything, absolutely everything related to arbitration. Arbitration agreements are only enforceable if they're in writing, and the parties are only required to arbitrate disputes that they agreed in writing to arbitrate. So Jeff and I had talked, and one important takeaway we wanted everyone to remember is often it's critically important to carve out certain procedures from a broad arbitration provision. Arbitration provisions are often incredibly broad and all-encompassing, but you may want to carve out certain types of disputes. If it's a commercial lease situation and you're the landlord, you may want to carve out your right to judicial remedies for eviction, since most states have quick eviction procedures. If you're a lender, you may want to carve out non-judicial foreclosure proceedings so that you can transact your foreclosure without arbitration. And again, an important thing to remember is because contract is the basis of arbitration, you can make arbitration your option. If you're in a deal and you have the bargaining power where you can pull this off, you can write it such that you have the option of either litigation in a forum of your choosing or arbitration. I've seen that fairly often in construction contracts with governmental entities, where the governmental entity will reserve that right to that they can choose either arbitration or litigation as their option. So again, if you have the bargaining power to pull it off, think about it, and it may be worth trying. Another important aspect to any arbitration agreement is defining your participants, and this can be really tricky, again, without going on to all the possible permutations. Obviously, there can be deals where there are multiple entities, there are multiple LLCs, there are individuals involved, as well as the corporation or LLC that's signing the contract, and you may want to have some simple side agreement where the other, where the holding corp or the individuals involved, or the individuals who control a single asset LLC, agree to arbitrate their claims, as well as the entity that's signing the contract. Again, just something to think about. And another important consideration in arbitration agreements, and Jeff and I, we often see this, where there is an arbitration agreement where it's a broad, any and all disputes arising out of or in connection with or related to this agreement shall be subject to binding arbitration, without any more specificity as to the procedures. Even if there's no specificity as to the procedures, the arbitration agreement is still enforceable, but the law provides gap fillers in the absence of procedural agreements. So we think it's a better course, instead of allowing the law to provide the gap fillers, to think through and decide what of the procedures do you want to define and how you want to define them. So I'll turn that over to Jeff to talk about that further.
Thank you. And again, this is not a bad slide to have as another cheat sheet the next time you're deciding that you're actually going to go and designate binding arbitration as a method for dispute resolution, to go through this and make sure you've checked off the boxes on all these, and so you made a full and complete decision. Obviously, the first part, binding or non-binding, for the most part, you don't, and I haven't had a situation in a long, long time where you'd want non-binding arbitration. If you're going to try to resolve it short of arbitration or reference or litigation, you might as well go to mediation. That's more of a developed body of law now. David already talked about one party can choose arbitration or litigation. Again, this depends on your leverage. If you can, if you're the one who can say, yes, I have full decision-making abilities, whether I want to do arbitration or litigation. For the most part, again, in a commercial context, those are the courts have pulled those types. Again, David talked about all disputes covered. Do you want to just have all disputes or just some of the disputes? Really important part is with respect to California and other states that have a summary eviction proceeding that David briefly talked about. California has an unlawful detainer procedure with respect to leases. You certainly, and for the most part, I get to court within 45 days to evict tenants. you want that fast procedure, and so you want to carve out from the arbitration provision that the eviction process can still go forward. The other is, again, California has a non-judicial foreclosure proceeding that usually in commercial settings and others gets the property back to the lender within about 4 months. Again, you want to carve that out so you don't end up with an arbitration procedure that may take longer than that. And again, even though it's very tough to undo an arbitration award, there's still ways that can cause delay. You want those types of things carved out from your arbitration provision. David briefly talked about potential parties covered. Again, you know, you want to make sure that everybody you can is covered by it so that you don't have dual tracks of litigation and arbitration. And typically what judges will do, if they would impact each other, is stay one and let the other go forward. A great situation there is if you got real property situations, is the broker covered by the arbitration provision or not. Going back to all disputes covered just for a brief moment, if you do want everything arbitrated, you got to be very broad, and in California you want to make sure that if it's an arbitration, you want to say any and all disputes, controversies, enforcement procedure, whether in tort or in contract relating to the deal documents. Number and selection of arbitrators, that's an important point for a number of reasons. One, let's talk about selection. You want a retired judge because a retired judge may act like a regular judge. Is this just going to be a contract interpretation? You may want that. Is this something that involves some type of a trade expertise? In that situation, you may want someone who's had 5 years experience doing leasing work or whatever the process may be. The number, for the most part, I suggest to clients, you really don't need more than the one neutral arbitrator. The idea of having 3 arbitrators, which is typically the exception to that, is each side has their own party arbitrator, you know, who tries to convince the one neutral to go their way, and so you end up with you usually end up at a 2-to-1 decision. My experience has been, and David may have other thoughts on that, is that it usually isn't necessary to have that panel of arbitrators. Arbitration service provider, that really provides a lot of help for you. If you just have a gap filler which says we're going to arbitrate and that's it, you don't have a process that allows you to select the arbitrator, to have someone to do all the administrative stuff. Yes, it costs something, but my experience has been it's really worth it. The concern, obviously, that you want to make sure about is that if you do choose AAA or JAMS or ADR services or another, is you look at their rules of arbitration, you look at their rules of mediation to make sure that whatever they incorporate is something that you can live with, or that you put into the arbitration provision that you're not going to include these things. JAMS, for instance, has an exchange of evidence program. JAMS has some situations that talk about the standard of evidence. You want to take a look at all of those before you incorporate. Specifying factors the arbitrator may consider, such as in valuation disputes, again, something to take a look at. Do you want to limit what the arbitrator can look at, something that happens sometimes in appraisal process? Preliminary relief we briefly talked about before. You want to be able to keep the status quo. California and the Ninth Circuit basically allow that for the most part without being considered a waiver of the arbitration provision, but it's still nice to have it in there. Discovery, as we talked about before, this is a way for you to limit the expense and the time and get to the arbitration award quicker if you can do that. Again, though, you got to consider the strategy of it. If you're the asset side of the deal and the developer side has all of the information, you obviously want to have a lot of discovery. California has a code of civil procedure that basically says you can take all discovery that you want if you incorporate this code section. Again, if it's equal and both sides pretty much have all the information already, and maybe there's just a situation where you want just a couple of depositions of the main players, you can put that in there, save some money, save some time, and move forward. Again, discovery is probably the most disruptive part of any type of dispute resolution, because it's not only the expense, it's the time of having the people, the business people, who would be better off making deals and making money than spending time having to deal with us lawyers. Remedies, a situation that you're allowed to do, at least in California, you can have a procedure that says, or a provision that says no punitive damage, no consequential damages, assuming everyone understands what consequential damages are, because The California courts don't seem to know that. And you want to put those kind of provisions in there. Again, you want it consistent with any other provision you might have in the deal documents above. So you want that. Attorney's fees, again, same kind of a situation. You want to make sure that the provision is consistent. California has something called reciprocity under the Civil Code that even though you say you're the lender that says, hey, if I win, I'm the prevailing party, I get my attorney's fees under California law and it's non-waivable, it basically means anybody who's the prevailing party gets attorney's fees. Location of hearing, again, you want it to be convenient as much as you can. Depends on leverage. You want to have it just like a forum selection clause. You want to have it where there's some reasonable connection to the dispute or the parties. And again, but think about it. If there's going to be a dispute and all the witnesses are in California, you really want a forum selection clause in an arbitration that says the arbitration is going to take place in Delaware. Sometimes you do, because if it's an LLC dispute, for instance, you may want the Delaware choice of law, choice of forum to make sure that it happens the way you want it to be. Deadline for completion, again, going back to the question that we talked about earlier, this is that situation where you want to say, hey, this is the process for choosing the arbitrator, this is the process for the initial hearing to discuss status, and that this whole thing ought to take place in terms of the hearing itself no later than 90 days or 6 months, and that 30 days after that the arbitrator must issue his or her award. David, let's talk a few more words about the benefits of arbitration.
Sure. Just some thoughts on commonly held views regarding the benefits of arbitration, and Jeff and I talked about whether we agree with these commonly held views on the benefits of arbitration. A quicker resolution, I think most people, the conventional view is yes, arbitration is quicker than your average lawsuit, and yes, I think 90+% of the time that's right. Arbitration does tend to move faster. Lower cost and attorney's fees, I think most of the time that's the right answer, but not always. One caveat to that is most arbitrations, especially through AAA or JAMS, the upfront filing fees are significant. You do have to pay the arbitrators, so your cost to the tribunal itself, you've got to pay AAA, you've got to pay the arbitrator. At least one good thing about litigation is you don't have to pay the court, I guess, unless you're a defendant in a small town where they have judicial elections, maybe you do. But so lower cost attorney's fees, generally that is a benefit of arbitration. Confidentiality, that is a huge benefit of arbitration, both as to your business information and as to publicity, keeping the media away. Arbitration, you can control where the hearing takes place. You can control access to it. It is not a public proceeding like a courtroom where if reporters pay attention, they can track the docket, especially federal courts. It's very easy to do that. They can see exactly what's going on. They can see exactly when any hearing is going to take place. And the same way with business information is in the court file. Obviously, the parties can ask for protective orders, which limits the access to information, but still, pleadings are always public record. Trials are 99% of the time public open proceedings. So there can be exhibits, there can be discussions of things that you don't want out in the public domain. Control over scheduling and flexibility. Again, some courts are reasonable and will work with you as far as scheduling, but by and large, we agree with this commonly held view that this is definitely a benefit of arbitration. And not just in the sense that you have some control over when something is scheduled, but there are situations where it makes sense to have 2 or 3 days of evidence in one location and then take a break and come back a couple weeks later and have days of evidence somewhere else. Again, that is possible in arbitration, not possible in a lawsuit. But at least with arbitration, the parties have some degree of control over that. Again, technical subject matter and educated decision maker, that is a commonly held view, and we agree with that. That typically does produce a better result, or at least one you feel like is more in your control as a party. And maybe the greatest benefit of it all is it certainly saves attorney's fees. Having an educated decision maker in an arbitration certainly makes the case much easier to prepare and much easier to present. And just as a concrete example, I did an arbitration last summer of a construction matter involving an excavation contractor. There were claims of whether the job was sequenced properly, whether there was interference with the contractor's ability to perform. So we had to get out plans, get out drawings, get out photos, and we had a non-lawyer serve as the arbitrator. And we handled that dispute in probably 8 hours of evidence, and it would have taken many days to have presented all that information to a jury. The jury probably would have never understood it, or it would have been very difficult and very boring. And so that would have been a week-long trial. It would have been much more expensive had it been in litigation as opposed to arbitration. If you're not a popular local entity, again, there are some types of businesses that when you think about it, you're probably better off with an educated decision maker in your field as opposed to a jury of 12 folks off the street. And finality of result because of limited appeal. Again, we'll talk more about it, but that's definitely, if that is important to you to get it over with, arbitration is a better route than litigation.
Thanks, David. Again, some people have common views regarding the pitfalls of arbitration. Just want to go through these a little bit. David's already talked about the ability to get discovery, so have I. If you want to, you can have full-on discovery just as if you were in a court of law. Again, usually it's the other way around. Clients complain about the expense of discovery, about the disruption of their business by having every single individual who touched a deal to be deposed. There's an ability here to limit the discovery. Again, due process in California requires, according to some case law, that you at least give the arbitrator the right to extend or the discovery additionally to the extent that there is good cause shown by one of the parties. David talked about the initial filing fees can be high and you have to pay for the arbitrator's time. That's absolutely true. On the other hand, as David pointed out, you can end up being cheaper in the long run to pay for an arbitrator's time because you get more time to get the matter resolved instead of going back again and again and again to the trial court, because the trial court only has a limited amount of time each day to deal with your matter, even while you're in trial. The judge is still handling other matters. The judge must give the clerk in California a 1.5-hour lunch. We just had an arbitration here in California. The arbitrator allowed us to go from about 10 in the morning to 6 at night with a 1.5-hour break for lunch. So we zoomed through the testimony and was much more efficient. We got done in a week, what probably would have taken at least 2 weeks or 3 weeks potentially in a court of law, just because we had it all condensed. Less likely to win on a legal issue. I don't necessarily see that. A lot of times, though, because the arbitrator tends to be a retired judge or a lawyer with expertise in a particular area, the legal issues do come out, and the legal issues are something that they focus on. Less helpful if you're popular in your region. Again, that's what David talked about before. If your company is one that everybody loves, you may want to go in front of a jury. I'm not sure that really helps so much anymore as it did about 20 years ago when there were various employers in various parts of the country that no one wanted to go against. Extremely limited ability to challenge the result. That could be a pitfall in the sense that it is true with respect to arbitration, especially in California and as David pointed out in Missouri. On the other hand, a lot of clients, they just want it done. They want to get it resolved one way or the other. They want it to be a reasonable decision, and then they want to move on with their lives and move on with their business. Does specialized knowledge help or hurt? Again, as David pointed out, if it's a construction case, you may want someone who's done a lot of construction work and has some expertise to understand the jargon, to understand how things work, and you don't then have to educate someone who's a retired judge. Interesting, though, if you go on any of the websites for arbitrators, for AAA or JAMS, all of them now have the bios of the potential neutral arbitrators, and they explain how, that they've had real estate experience or construction experience or labor and employment experience. So you can actually be more informed about that during your selection process. ability to involve all parties to the dispute. Again, we've talked about that briefly. Again, it's the situation of, are you going to have dual tracks, or is there a way that you can involve, you know, all the potential parties to the dispute so that you get one and final resolution? And again, delay summary proceedings like eviction and foreclosure. Real important drafting advice is that, hey, when it comes to those kind of things, California is a great example, as we discussed before. You want to carve those out so that you're not hampered and delayed by having to go through the arbitration procedure, which will likely take longer than the summary proceedings of eviction or non-judicial foreclosure in California. We're now going to talk a little bit more about arbitration, and David's going to talk about some of the other key facts of arbitration.
Yeah, really, and just to put a final note on arbitration, one thing that's critically important to explain to your business partners, your internal client, is when you agree to arbitration, the loser in the process has an extremely limited ability to challenge the award. And I won't go through all these bullet points here on the slide, but the judicial review is basically limited to proving that the arbitrator engaged in some type of fraud. There is no motion to reconsider. There is no motion for new trial. There can be review if it is apparent from the four corners of the arbitrator's decision that the arbitrator made a clerical error or a calculation error. But beyond that, there is really no court review of an arbitrator's decision absent some type of fraud. So that's just something, again, it's important to advise the business decision makers and kind of the institutional view of how your entity wants to handle disputes. Is it important to be able to feel like your rights were vindicated? Is it important to feel like you had an opportunity to fight till the end? Because in arbitration, once the arbitrator decides, that's really it. Whereas in a court of law, at least there is some appeal right. That's always an uphill battle if you lose, but at least there is a right. There is an ability to challenge a decision where the damages are just too high or the court was wrong in interpreting a contract. With an arbitrator, there really isn't that opportunity to say that your interpretation of the contract is correct and the arbitrator's was wrong. So that said, given the limited ability to challenge an arbitrator's decision, that is an important concern, an important consideration if you are going down the road of committing to arbitrate all disputes. So Jeff and I had talked about, and California has really a unique system that is more or less a hybrid of litigation and arbitration, and special reference procedures that exist in California. So I'll turn that over to Jeff to explain that.
Thanks, David. And as David pointed out, California has for the last several years something called a judicial reference proceeding. It basically allows kind of a combo platter of both arbitration and litigation. One of the concerns in California, especially after the California Supreme Court in the Grafton opinion said that the parties can't, before a dispute, put into a contract that there's a jury waiver, is getting away from juries. And that's why a lot of people go for arbitration, binding arbitration. This judicial reference allows that same thing. It has the benefit, just like arbitration does, of excuse me, in effect, having a jury waiver. Again, you got to put it in the contract like anything else. The benefit for some people is the idea that, as we pointed out, the last two bullet points, is that the referee who is appointed, who is again usually a retired judge or a lawyer with experience, just like you would in an arbitration procedure, is that referee's decision actually becomes a trial court judgment. So it becomes part of the public record in the lawsuit. So you file the lawsuit, and in the lawsuit you have an allegation that says the parties agreed to a judicial reference. You go through the procedures in the judicial reference provision in your contract about the selection of the referee and all of those kinds of things, including discovery, where it's going to take place, things of that nature. If you can't decide any of those things amicably among the two sides, you basically go to the presiding judge, and the presiding judge is the one who makes the decision based upon usually the nominees given by each side as to who the referee ought to be. Once appointed, the referee, just like an arbitration, decides where the reference is going to take place and makes decisions just as if he or she were a trial judge. And the benefit there for some people is when they get worried about an arbitrator being all-powerful and that the award being very difficult to attack, is that because it's just like a trial court judgment, you have a right to post-trial motions like a new trial motion or a JNOV, and you also have a right to appeal. So you have that right that you wouldn't have under a binding arbitration where, yeah, you have a right to appeal, but it's in a very, very limited setting. This one would be just like any other court judgment that you would have this right to appeal. So why some parties like this, why some clients like this, is it gives them the idea of choosing the referee, choosing and selecting discovery procedures, getting it done perhaps a little more cheaply than just going to litigation, maybe getting it done quicker, again, because someone is focused directly on their dispute alone. And then if the arbitrator or the referee makes a huge mistake of law or a huge mistake of fact, at least there's a right to appeal. Dave is now going to talk about whether there's something similar to that in the state of Missouri.
Yes, and to talk a little bit about the special master provisions, both the federal rules and Missouri rules allow for matters to be referred to the buzzword here is special master as opposed to judicial reference. And a special master, it's much like decisions are referred to magistrates for reports and recommendations in the federal court system. But a special master can hear evidence, issue a report with findings of fact, conclusions of law. So a special master can certainly hear and decide any aspect of any lawsuit where the parties agree. The difference between this federal and Missouri procedure as opposed to the California procedure is California law makes it clear that the parties can agree to this judicial reference procedure and incorporate the California statutes that define that procedure. In Missouri, I've never seen this. I've never seen an ADR agreement, pre-dispute agreement to send something to a special master because really the court must agree to it. The court may or may not appoint a special master, and the court may or may not agree with the parties as to the extent of the appointment, the scope of the appointment of a special master. So a special master under federal or Missouri rules only has the power that the trial court's order gives the special master. So while it's not absolutely necessary for the parties to agree to all aspects of it, most of the time I think judges do want the parties to agree to it, encourage the parties to agree to it. But it's, frankly, this is a procedure that, again, it's not typically written into contracts pre-dispute, but it does provide a good option for parties once a dispute has arisen and once there is litigation underway, that I've seen situations where both parties agree that a special master deciding the case, much like an arbitrator would decide the case, is preferable to just marching through a lawsuit. And again, this is similar to an arbitration, but it has different advantages, that there is judicial supervision of the process, there is appellate review, there is that authority of a judicial proceeding as opposed to an arbitration, meaning there's full rights to discovery and subpoena power that's equivalent of that of the court. It actually results in a court judgment. And one important aspect of it with a special master is there is the ability to join all the involved parties, whereas in an arbitration, if you have, obviously that only binds the parties that have a written arbitration agreement. So special master may allow you to include all of the involved parties, whether it be related entities or individuals as well as corporations. And one other advantage to paying to special masters, again, while you have to pay the special master, at least you aren't paying an arbitration service to oversee that. You have the judge overseeing it. And I know we handled a condemnation case several years ago where it was just a question of damages, but there were really complicated questions about the scope of the taking. This was going to be taking part but not all of a multifamily property, an apartment complex. It was going to be taking part of it, not all of it. In addition, it was going to be taking part of it for some 3-year construction easements. So it would have been very complicated to define the scope of the taking. The jury would have been incredibly bored. The trial would have taken a long time with the jury. And we ended up trying the case by a special master because we were able to present the evidence much more quickly, get into the nitty-gritty details and the plans and the drawings and the scope of the easements that the jury would have been bored to tears hearing. So that one worked out really well. We were happy with the result. I don't know if the other side was happy with the result, but I think they were at least happy with the process of the special master. So with that hybrid as our last consideration, I'll turn it back to Jeff with just some final thoughts.
We've run out of time, and we really appreciate your presentation, your attendance at our presentation. Final thoughts, again, we would just suggest that how you go about your ADR provisions and what to include and not include is really on a case-by-case decision-making basis. It's not a boilerplate decision, and the provisions themselves are not boilerplate. They should be thought through in the sense of if there is a dispute, and hopefully there won't be, how is this going to play out, and what's the best way for you to get the best result in as quick a manner as you can for as least expense as you can. We want to thank you for attending today, and if you have any questions, please give David or me a call. If the last slide we have has our contact information, give us a call. Obviously, we're also on the Thompson-Coburn website if you lose this. Again, thank you very much.
Thank you.